Mr. Speaker, twice this week, the Premier said here that the public trustee must act in the best interests of the individuals for whom the trustee is responsible. August the 7th, 8 days ago, at the committee meeting on the Public Guardian and Trustee Act, Kerry Anderson spoke about his aunt, Dorothy Loewen. He said the trustee walked into my aunt's house early January 2012, told her she was mentally incapacitated and was now a ward of the trustee. Since then, both Dr. Campbell, a renowned geriatric psychiatrist, and Dr. Hayward have said she is actually not mentally incapacitated. I asked the Premier, how is it in the best interests of a person who is mentally competent to have her life taken over by the public trustee?
Very much, Mr. Speaker, and it's certainly helpful to have bills move into committee so Manitobans can come and indicate their views, and it's a very, very good thing, and I'd like to see a lot of other bills move on to committee to hear from Manitobans. And I'm grateful to individuals who I know are up in the gallery who came and presented thoughtful presentations at committee. I believe that the leader of the Liberal Party should be aware that the public trustee does not designate itself to become the committee. There are procedures under the Mental Health Act which are not contained within the public trustee's office. I would point out that anybody who's appointed a committee, whether it's the public trustee or whether it's a private individual, are bound to follow the best interests. The public trustee should be held to the same standard as any other Manitoban. We think that's appropriate, Mr. Speaker.
Mr. Speaker, the family members, Marg and Len Anderson, who are with us in the gallery today, they're very concerned that even as the matter of whether Dorothy Loewen is mentally competent continues to be debated now for 19 months, the public trustee has been making day-to-day decisions. These decisions are depleting the bank account of Dorothy Loewen, and the trustee has also indicated that to the family that they want to move Ms. Loewen out of her home and put her in a personal care home. I ask the Minister, is it in the best interest of a person like Ms. Loewen to have the public trustee acting with such unilateral authority, even before the courts have provided a final ruling on whether or not she's mentally competent?
Very much, Mr. Speaker, and as the leader of the Liberal Party has suggested, there are some disputes in this case that are before the courts that I won't comment on. I would point out, however, that when an individual is in need of assistance, it is important to have a body there that can act in the person's best interest to take care of their financial needs as well as their physical needs. Under the authority of the Mental Health Act, the public trustee has been appointed to do that very thing. What I told the member at committee, and what indeed I told the Anderson family at the hearing, is that we want to improve the Public Trustee Act to make it easier, should there be a valid and enduring power of attorney, to make it easier for the public trustee to remove itself if indeed there is a family member or friend who's been designated by the person in need of assistance. We think that's an appropriate way to move, Mr. Speaker.
Mr. Speaker, the Premier said yesterday, and the Minister reiterated, that the trustee, just as members of the government, will act on behalf of that person's best interests. Now, I first wrote to the Minister of Justice on the unnecessary intrusion of the public trustee into Ms. Loewen's life on January 16, 2012, shortly after it began. 19 months later, the situation is unresolved, and Ms. Loewen now fears being inappropriately relocated into a care home. Can the Minister explain how such a traumatic and costly delay in addressing this situation shows that the public trustee or any member of the NDP government is acting in the best interest of this citizen?
Well, I think it's important, again, for the member to understand that the public trustee is acting under the authority of the Mental Health Act. The public trustee does not, in and of itself, take control of people's estates. I'm aware there is a dispute. I am aware that there are family members who have a different view. I am aware that those family members have brought an action in the courts, and an independent judge, with all the facts, will make a determination on whether the public trustee should continue, whether indeed there are valid and enduring powers of attorney that should be given precedence over the public trustee. And I can assure the member that the public trustee's office will respect whatever that decision should be. But let me tell the member opposite that it is not the place of individual members to make political decisions on matters such as trusteeship and looking after vulnerable people, best handled under the Mental Health Act, best handled under
Order,
common
please. The
T-shirt
minister's time has expired.